So thanks again, Justin, for being here. I appreciate it. And what we're gonna do now is let's, as you say, break down some of the pieces of what that contract looks like.
Okay.
We have what we could refer to as the contingencies, typical contingencies on the contract, which would be typically a financing contingency, normally the mortgage, and then we also have inspection contingency.
Right.
So let's focus on the inspection contingency piece. I find that to be an incredibly challenging piece, and oftentimes what we'll say to our sellers is that getting you an accepted bid is literally, I'm halfway there.
Yeah.
I'm halfway there, and getting you now contract to close, it's a lot to deal with, a lot of moving pieces. The inspection, so the term "as is" comes up a lot.
Yes.
Sellers say, "I'm selling the house as is," and then buyers, buyers basically sometimes tend to use the inspection as, a way to find out what's materially wrong with the house, but maybe also a way to
second chance to
a
renegotiate.
little bit. and in defense of them, maybe there's only so much they see when they're going through the house, and then they find out stuff that they then see through an inspection, and they feel like the value is changed.
Right.
So this is confusing and gray, and you're amazing at helping us through that. I'm saying Justin helps. You're a team player with this. It's never black and white.
No.
And you're really great at helping us manage and communicate through this process. So I just want to say thank you. So tell us how you do it.
Well, to go back a step, oftentimes a client will ask me, what am I supposed to do during the inspection? So I try to explain, look, the purpose of the inspection.
And are you saying a buyer or a seller?
A buyer. What am I looking for? What can I raise or what can't I raise? And I say, listen, when you make an offer on a house in New Jersey, you don't really have an opportunity to really thoroughly check the house and see if there are any latent defects or anything like that. So you're making an offer based on your general understanding of the condition of the home and market conditions and things like that. As opposed to, just to use an example, in New York, you do your inspection and then you make your offer.
And
it's a very different process.
Right. It's New York, and so in New York the house stays on the market.
Right.
Yeah.
And that also opens a whole other can of worms where in New York. Yeah. The inspection negotiations tend to be a lot less severe.
Right, and that's part of the conversation I have with my sellers all the time. The sellers tend to feel like they're being held hostage to a buyer because you are literally off of the market until such time as the inspection contingency is satisfied and you're moving forward, or you're back on the market.
Right.
And if you're back on the market, the agents and the very savvy buyers will know that you were in contract and now you're not in contract.
And
so
why
did that happen? So now you have a stigma.
Right.
So you probably think about all this stuff while you're helping.
So when I get asked the question in advance, I say, listen, the purpose of the inspection is to help you determine if there are any latent defects that you wouldn't have noticed by walking through the house the one or two times before you actually make your offer. So if you saw that the cabinets were worn, or the wood floors weren't perfect, or the siding isn't perfect, you should have factored that into your offer. But you don't know if the leak is roofing, if the roof is leaking. You don't know if the boiler's leaking.
Right.
You don't know if there are serious, structural defects or anything like that. So the real purpose of the inspection is to protect you from those types of defects. And if there are things that are going to have to be fixed, that's your opportunity to say to the seller, and technically you're supposed to say, these are the issues, I want you to fix them. Now the seller can say, I'll fix everything, in which case you have a deal. The seller will probably not say, I'll fix everything, but they might say, I'll fix a certain number of things, that I'm not gonna fix, I'll give you a credit for that, and at the end of the day, it becomes a negotiation where you get to the point where you're comfortable enough to move forward,
right.
And the seller is willing to do enough to make you satisfied.
So inspections. So basically, we're saying that inspection is essentially an opportunity for you to identify things that you probably wouldn't have known by going through the house once or twice. And where does the seller's disclosure fit into that? And can you just give a brief explanation of the seller's disclosure? Because for us, we feel that seller's disclosure does provide a lot of transparency
Mhm.
to what the seller is identifying could be potential things that maybe aren't working. Maybe something's not working. We disclosed it, and therefore we shouldn't be on the hook
Right.
for repairing it or fixing it because we told you and you signed it,
Right,
Mr. and
right.
Mrs. Buyer. But
Yeah.
what
Well,
do you think?
that's actually a great question, a good point, because I've been practicing since before the seller's disclosure was even a thing, right?
Wow, you're that old.
So when the seller's disclosure became more common, some companies were using them, some companies weren't using them, some companies left it up to their individual agents to decide whether or not they would use them. So I had my concerns about how valid would they really be?
Right.
Do the sellers filling these things out really know what the information they're giving? Are they potentially not being honest? Are they lying outright? So what I do say to clients when they're reviewing it, I say, look, if the seller's telling you something that's wrong or something that's clearly going to be a factual information, it's good to know. But you can't be 100% certain that there's not something wrong that they haven't disclosed, because maybe they don't even know it,
Absolutely.
or maybe they're not really being honest. So there's definitely a lot of good information there,
Right.
but that can't be your only basis to determine the condition of the home. And again, not just because someone's going to be dishonest, because as homeowners we don't
You don't.
really
They don't. They don't
we
know.
really
No, I agree with you. So I think the only thing I just want to make clear and is this black and white, which is a leading question. If a seller puts something on the seller's disclosure and the buyer reads it and signs it, and then the buyer comes back in the inspection letter with a request
Mhm.
for them to repair what they were told wasn't working.
Right.
Now, naturally, my sellers are like, Stacy, we
Right,
told them
right.
this wasn't working, so what do you suggest?
Legally, no. There's no estoppel would be the technical term for them to bring it up. Maybe morally, or ethically, if they knew there's something wrong with it, they should not be asking for a credit for something like that. But by the same token, just like a seller could make a mistake, maybe the buyer missed something. You never know.
You never know, and it comes back down to whether or not they're going to be open for that negotiation.
Right. Some attorneys I've seen actually try to put in their attorney review letter, their amendment to the contract, that the seller's disclosure statement is incorporated into the contract by reference or something like that. But absent that, the seller's disclosure is for information only. It's not a part of the contract. It's not legally binding.
Right.
And again, unless the seller committed some kind of an intentional fraud,
Right.
if the information in the disclosure is wrong, then there's nothing you can really do about it. And that's why the inspection is very important, but it should not really be an opportunity to just renegotiate.
Right.
And I know that people do go into it thinking, I'm going to ultimately pay what I wanted to pay.
Right. Well,
By
I think
using my inspection.
I think that it's a little I think it's unfortunate. I don't happen to like the way it's done here in New Jersey.
We could talk about that for hours.
Okay. So Justin, this is a perfect segue into this as is. And when you read the contract, it does say that the house is as is.
Right.
So what does that actually mean?
Right, because oftentimes people say, it's as is, why are they doing an inspection? Or
Yeah, it's as is.
the seller usually says, I'm selling my house as is. I'm not going to fix anything. So the reality is that's exactly why there is an inspection. Because what as is means legally,
Right.
and what as is means to people buying and selling homes are sometimes two very different things.
Okay. So
Okay.
hold on. So what does as is mean legally?
So the legal term as is means that the property is being sold without any warranties or guarantees about the condition of the property, what it's going to be like before closing, what it's going to be like, more importantly, after closing. So in theory, you could close, and the day after the closing, the house could fall down, and that's the buyer's problem. I mean, that's obviously the extreme, and that doesn't happen, but as is means that as of the date of closing, the buyer's taking the property subject to whatever faults were there.
Okay.
And that's why it's important to do the inspection and determine, are there any faults that nobody knew about?
All right. So conceptually,
Right. So
the as is, yeah.
what sellers often think as is means is that you're buying my property no matter what condition it's in right now. And that's not what as is means.
Okay.
Now, if a seller says, look, you're buying my home as is and I'm not going to fix anything, So do your inspection and tell me whether or not you're moving forward. That's great. That's exactly what the inspection is for.
Right.
That's perfect. But oftentimes sellers think that they're going to say, do your inspection, but I don't care what faults you find, you're buying my house.
Right.
And that's one of my jobs, is to make sure that
Right.
as a seller's attorney, I manage expectations of my client. And when I'm the buyer's attorney, the same thing, managing the expectation, as we mentioned earlier, about
Right.
this isn't the opportunity to renegotiate the contract.
Right.
If you find something wrong, we'll deal with it.
So I also want to say that even though in New Jersey we're off the market while we're doing inspections, typically we can do deals where we ask the buyer to do an inspection prior to going under contract and coming off the market. And when the seller has that kind of leverage, we do it, and it's pretty awesome, actually.
I don't think it's a bad thing. The only risk to the buyer is, look, maybe they spent $700, $800, $900 or whatever it is, and the seller could get another offer and they could back out of the contract.
Right.
That's really the only risk.
So what you and I have actually done before, and I know you do a lot of deals, you might not remember it, but we did is we made an agreement with the buyer and the seller that we would give them 1 week to do the inspection, and during that time we wouldn't show the house. We wouldn't show the house, but we didn't take the house off the market.
Right.
And so it was a little
fair trade-off.
A little bit of a fair trade-off. I hope it's legal through the MLS, but yeah.
Oh, well. that I can't speak to.
But I mean, it definitely helped. So, and yeah, it basically, and the other reason why it's a fair trade-off is because not technically, standard operating procedure for when the deposit is due. So let's talk about that.
Okay.
So standard operating procedure for when the deposit is due comes once the house is under contract, right? So then the clock starts ticking
Right.
once the house is under contract. So if you're waiting to get under contract till you do your inspection, which is not normal, you essentially now have a longer time frame for when the deposit is due, right?
Yep.
But let's go back to the way things normally happen in New Jersey, and let's talk about when that deposit is due and the relationship between the deposit and the inspection.
Right. So I guess somewhat coincidentally, the deposit and the inspection are generally timed around the same. What I mean by this, usually the deposit is due 10 days more or less after the end of attorney review. And normally the inspection is due, or the inspection contingency period would expire 10 to 14 days after the end of attorney review. But in reality, one should have nothing at all to do with the other.
Should have nothing to do with it.
I think I mentioned to you once that I have worked with some realtors who say, if you do your inspection, we're not going to answer any requests until the deposit is in. My response to that is, if the deposit was due and we didn't give you the deposit, by all means, you don't have to answer me. But if I get my inspection done in 4 days and the deposit's not due for 10 days, why should we waste time with not getting an answer on the inspection until the deposit's due? So one thing really has nothing to do with the other. When clients who are buyers say to me, I don't want to give my deposit because we haven't done our inspection, my answer is, listen, the inspection contingency is pretty straightforward. If we can't come to an agreement after your inspection's done and after you make your requests, the contract will be terminated and you'll get your deposit back.
So let's stop there for a second. So Justin, let's talk about the deposit. People get really anxious and nervous when it comes to parting with that kind of money.
Yep.
Typically, the deposit would be about 5 to 10% of the purchase price, and it's normally held in the seller's attorney's escrow account. People get really anxious about that. You know, they get anxious about it, and as you said before, sometimes they don't want to actually put the deposit down until they've had their inspection. But as Justin just explained, they really should have absolutely nothing to do with one another. What I find so interesting is how many misconceptions there are about what happens to that deposit money if there's a default.
Okay.
And I mean, very smart people who are brilliant at what they do are often under the misguided notion that if there's a default by the buyer, that the money will just literally go from the escrow account to their account, and it's not, obviously not the way it works. So I wanted you to share with us.
Well, there's a couple of, I guess, steps before anything like that would happen, and one thing to recognize is that New Jersey is what we call an actual damages state or jurisdiction. In some places, the deposit is would be considered liquidated damages. What that means is if there is a default,
That's right.
the non-defaulting party has one job: prove a default, you get the whole deposit.
Right, so that's interesting. So that's not New Jersey.
It's not New Jersey.
So New Jersey, so the deposit money is not liquidated damages. The burden of proving the damages is still out there.
Correct.
Is what so the money that's sitting in the money that's in deposit. My sellers will say, well, if it's not going to go directly to me, well, then what's the point? You know,
Right,
well, what does it matter? Then there's no real skin in the game. Like, and so how do you answer that?
So if there is a default, okay, then in New Jersey we have a two-step process. The first step is to prove that there's been a default, and then the second step is to quantify your damages. Figure out what was really the harm done by the buyer not performing as the buyer was supposed to perform under the contract.
Okay, so let's say the amount of damages. So there has to be proven that there's default,
Right.
and then there has to be an actual number associated with the
Correct.
damage. So while that number is being proven, and you're going to tell us how you prove that number, what happens to the money?
It sits in the escrow account until either the parties negotiate some type of a resolution, which fortunately I've only been in this situation very few times, and in all those times it's been resolved by negotiation.
So you've been doing this for about 18.
I've been on my own for 18 years.
Okay,
and
and
doing
of
real
those-
estate transactions.
And of those 18 years doing real estate transactions, how many times has it gone to court where you were fighting over escrow?
Zero. Zero. Yeah, zero.
0 times. You're a good attorney.
Well,
Yeah.
I think maybe I'm lucky, but
Yeah.
no. So what? Because what normally would happen if there is a full blown default, you're gonna figure that this is going to take a really long time to resolve, and maybe there's a better way to come to a resolution. But
so let's go back to what,
Yeah.
right, so basically it very rarely, if ever, happens where it'll escalate to any type of legal situation, but the burden of, is there a default, and then damages.
Right.
So that money sits in the escrow account until there's a resolution.
Correct.
Right? So 200, 300, whatever the number is, that's a lot of money to be sitting outside in an escrow account. So what qualifies as damages?
So if the buyer, clearly at this point we're talking about a buyer's default. So if the buyer were to default, the seller has to quantify damages. The way the seller quantifies the damages is the money sits in the account, the seller declares you are in default, then the property's got to go back on the market. Okay? And the seller's got to find another contract. There's an obligation to accept a reasonable offer. You can't just sell it to your cousin for
Right.
$1 million less and say, oh, you owe me that money.
Right.
But you also don't have to go out of your way to maximize the amount that you're selling for. You have to make a reasonable attempt, a reasonable effort to sell the property at a market price. So let's just pretend you're selling a house for $2 million.
Right.
You're in contract, the buyer defaults, you go back on market, you sell it for $1.8 million. There's $200,000 of damage there.
But Justin, what about, the moving costs and the pain and suffering and
Right.
all of that anxiety and the
Can't-
and the sessions with my therapist over there? I mean, I've heard everything,
Yeah.
right? They sold all their stuff. They're living on the floor. I'm just saying, damages. So damages is you're only talking about the difference in the sale price
No,
for damages?
anything that's a direct result of the failure to sell the property. Now, a buyer can't be responsible if you made them, you sold all your furniture, or if you went in contract to buy another house. Those would be considered consequential damages, and that's not immediately applied.
So wait a second, so if I'm under contract, all inspections satisfied, and then the buyer just can't close. So there's a legitimate default.
Mhm.
We've established that. And I have put down, 3 months rent on an apartment
Yeah.
that I default on because my buyer's defaulted on my house sale.
So I'm not a litigator, thankfully, but though that would not be considered direct. What would be considered a direct damage or an actual damage would be the carrying costs of carrying that property. So we know you have to live somewhere, right? So you can't get the compensation for owning this house for 3 months and now owning another house for 3 months, or renting another house for 3 months. You get one or the other.
Right.
Okay, so you would be entitled to the difference in sale price, the carrying cost of that property for however long it took between when you were supposed to close in the original contract and when you actually closed in the next contract. But whether you move or not, I mean, whether the person defaulted or not, eventually you were going to have to move, so you can't get moving expenses. If you need to consult with a psychiatrist, that's probably on you too.
It's a lot, and you know what? This is such a great conversation because I just think that it tends not to be that clear to a lot of people. And like you said, it differs state to state.
Yes.
You know, it differs state to state. So we're going to stop there, and then we're going to pick this back up with our next session, and we're going to talk about closing dates, time is of the essence, and how to plan for your move.